Hi, I'm Tricia Dunlap, a small business attorney at Dunlap Law in Richmond, Virginia, here today to talk with you about some of the pitfalls of going into business with your buddy. We see this all the time here at the law firm. We frequently get clients who maybe 3 or 4 or 5 years ago went into business with a friend or a couple of friends, but at the time they thought they would save some money and not hire an attorney. It turns out that was a big mistake, and it ends up costing them far more several years later to try to unwind the problems that were created because they didn't get it right from the start. I want to talk in depth about some of these pitfalls, but first let's start with the beginning of a business venture. It's a really exciting time. You and your friend or friends have a great idea and you're sure it's going to work. And one of you maybe has some capital and the other one has some experience, and you're going to go in together and you're going to build something that's yours, that matters. And this is a time of great optimism, and that's wonderful. It should be. If we weren't hopeful, nobody would ever start a business because it's hard and it's scary. So you've got to be hopeful. That's reasonable. But you should recognize that the way our brains work, the way human nature works, is when we are optimistic about a new venture like this, it also makes us blind. It makes us blind to the pitfalls, blind to our own shortcomings and those of our friends, and blind to the critical importance of getting the right deal in place at the start. That's what a good attorney is for. A lot of people don't really understand the role of a business attorney, so let's talk about that briefly. My job is to help you see past the blind spots that you've already got today. My job is to help you understand some of the foreseeable problems that could arise in the future, and then to put measures in place right now in a carefully drafted document that will prevent misunderstandings and problems in the future. A lot of people think that a lawyer's job is just to draft some documents, and that's really not the case. One of the words for a lawyer is counsel. And the reason why a good attorney is also called counsel is because that's what we provide. We provide advice. We help you see into the future and to see some of the problems that could arise so that we can get it right at the start. It's critically important that you have a good advisor at the beginning of a business venture. Every business will have governing documents that dictate how the business partners operate with one another, how they treat one another, how new partners might join or how existing partners might leave. All of these are big questions to answer. It's important to get those governing documents right at the beginning. If you don't get them right at the beginning, then it's almost certain that misunderstandings are going to arise, and then you will need a lawyer years down the road to unwind some of the problems that have arisen because the governing documents don't help you govern. This is a really important time as you get ready to launch a new business. It's such an exciting time and you're really optimistic, but this video will help you think through 3 of the most basic questions that you've got to answer before you start your business. Number 1, what will you each contribute to the business? All the time, I have clients come to me who have been in business with their friend, and one of them contributed money, and the other one is supposed to contribute sweat equity or maybe industry knowledge, or maybe they'll be providing marketing services or some other like in-kind contribution. And inevitably, over time, the person who was supposed to contribute the services, maybe they get distracted, maybe they have other interests that are capturing their attention. For whatever reason, they're no longer contributing as many services and as much time as you thought they might at the beginning. And then the person who put the money in is looking kind of sideways at the person who's supposed to be putting in services going, hey, Aren't you supposed to be doing XYZ? So you've got to think really carefully if you're going to be contributing different talents or different amounts of capital, you've got to be really careful in how that's structured and how that's accounted for. We have lots of experience in putting together deals like this, so we've got ideas that can help you. But you've got to have a plan for addressing this. Question number 2. Will your rights in your business be proportional to the contribution to the business? So for instance, if one person is putting in $100 and another person is putting in $100, that's really simple. You're each 50-50, right? Well, it's almost never that clean when people are starting a business. Typically, one person has more capital assets than another, and so they're willing to put in more capital, and the other person is perhaps putting in either services, or perhaps they have equipment or inventory that they're putting in, and oftentimes these things are mismatched. So how are you going to handle that? Is the person who's putting in capital going to have more say in the running of the business or not? This is an important consideration, and we can help you adjust for that in your governing documents. Thing number 3, what if someday one of you wants to resign? What if one of you wants out of the partnership after a couple of years? Do you want to allow this or not? If you don't put this in your governing documents, then under Virginia law, it might be extremely difficult for the person who wants to leave an LLC to actually get out. In fact, you might be trapped unless you go to court. So it's important to think through whether or not a member can resign from an LLC. And if they can resign, what are the terms of that resignation? The members who are going to stay in the LLC don't want to be caught short because somebody wants to leave. So again, this has to be carefully structured, and we have lots of experience with doing this, so we can help you figure out what that structure should look like. So those are the top 3 things you should be thinking about. Number 1, what you're each going to contribute. Number 2, whether or not your rights in voting and governing the LLC should match the proportion of your contribution. And then number 3, whether or not members get to resign, and if so, what are those terms? Those are the 3 most important issues that we see as people have gone into business with each other, and then down the line they have problems. 3 more things that you should think about as you get ready to go into business with a friend is, number 1, whether or not you need a prohibition against engaging in competing business activities. Think about it. You go into business with a friend, and 3 or 4 or 5 years down the line, that friend is perhaps distracted and they're no longer working in the business that you've started together. And in fact, they've started a side hustle that's actually competitive to your core business that you started together. Should you have terms in your governing documents that prevent this from happening? That's a really tricky question, and we can help you think through that as you get ready to launch your business. The second thing you should think about is whether or not your LLC, which is the normal form for people going into business nowadays, it seems to be the default, whether or not your LLC will be managed by all of the members, or whether you're going to designate one person who will be a manager of the LLC. Now, a manager could also be a member of the LLC, but not necessarily. Sometimes an LLC will actually hire an outside person who's not a member to act as the manager of that business. If that's the case, then you want to think carefully about the scope of responsibilities and the scope of authority that that manager is going to have. If you're not going to have a manager, then you need to think carefully about the scope of authority that each member is going to have. Will members be able to go and sign a contract on the behalf of the LLC and bind that LLC without talking to other members? That could be dangerous. But if you put in terms that are too restrictive, it could prevent the LLC from being effectively governed. So again, this is a tricky balance, and we can help you strike that balance. The third thing that you should consider is whether or not a new member can join the LLC. And if so, what are the terms for that? Will the existing members be able to have a majority vote on a new member joining, or should it be unanimous? If a new member is joining, what kind of contribution should they be required to make as they join? And How will the membership interests of the existing owners be handled? Will they be evenly diluted, or will their ownership interest be diluted a little bit differently depending on their contributions? All of these are tricky questions around the future addition of new members to a limited liability company. So these are issues that you need to think carefully about as you get ready to launch your new business with your buddies. As small business attorneys, we specialize in helping you solve these questions and coming up with an operating agreement or articles of incorporation and bylaws that will really help you get off on the right foot with your new business. These governing documents are going to be essential to your future success. I hope this video has been helpful. If so, please like, subscribe, and share. I'm Tricia Dunlap with Dunlap Law in Richmond, Virginia. Thanks.